you for being here today. This is a very important issue. The way I can tell that it's an important issue has a lot to do with what I see at town hall meetings. This is an issue that just a few years ago was very rarely discussed outside of the sort of wonky circles that we see inside of Washington. But this is something that has now become important to people, not just on K Street or on Wall Street, but on main streets throughout America. I hear about it routinely from small business owners across my state and from throughout the country. It's a subject that we need to pay more attention to, and there's a lot of enthusiasm on this committee for patent reform, which I think has now become indispensable for American businesses, large and small, who want to be able to operate and grow without fear of extortion from patent trolls. For example, unscrupulous entities who will send your small business a letter accusing you of infringing one of their asserted patents with the Wi-Fi router you happen to use in your small business, perhaps allowing your customers to access it while in your store. But in this demand letter, although you're told that you're infringing, you're not told how you're infringing, and you're threatened with litigation, and you receive a demand for payment. Last Congress, this committee worked hard to pass patent reform legislation that would crack down on abusive practices in patent litigation. Senator Leahy and I worked together on a bill called the Patent Transparency and Improvements Act that would have attacked the problem of demand letter abuse and would have protected businesses like retailers who use equipment manufactured by someone else from having to immediately defend against infringement claims. Meanwhile, Senators Grassley and Cornyn proposed important reforms to address the way patent cases are tried. Their reforms were designed to make the business model of these patent trolls unprofitable and to give parties the incentives to conduct efficient litigation in patent infringement cases and to, of course, hold them accountable when they impose unreasonable burdens on each other. I'm hopeful that this year we'll succeed in uniting these reforms and that we'll finally pass legislation so desperately needed by American businesses, both big and small. Mr. Anderson, in your testimony you described some of your experiences with abusive patent infringement demand letters. How does a business like yours decide whether or not to pay up on a demand letter? In other words, do you try to evaluate the merits of the infringement allegations against you, or are you more likely to just try to size up the size of the demand and weigh it against the inevitable cost of litigation?
The routine is I try to gather, thank you, Senator, as much information as I can, but ultimately we end up in the same place. We can't afford to litigate one of these cases. There's too much unknown information out there, and so ultimately we know that we're going to enter into a license agreement. As the question is, can we negotiate that price down a little bit? But as I said in my earlier testimony, the price has nothing to do with the technology. The technology may be something that really doesn't drive business and may not be worth much to us, but somebody alluded to earlier that maybe you could just stop using the technology. That doesn't matter because you're still responsible for past use. So at that point in time, the demand is not going to go down very much if you cease using that technology. So it's just a question of trying to reduce my outside attorney's fees with the IP attorney and reduce the licensing fee. But that's where we end up.
If you had to identify just one reform or, say, one small list of 2 or 3 reforms that would help alleviate this problem, what would that or what would those reforms be?
Senator, it would be difficult to narrow it down to 1 or 2 or 3. We're looking for comprehensive reform. The more that you can do for us, the better. This really is crippling to our business, and it's steering us away from technology, which are, as I said before, our customers want, our franchisees want, and we really would like to give business to this small innovator.
Would it help, separate and apart from what other reforms might be helpful, would it also help if Congress somehow channeled the FTC's enforcement activities toward going after demand letter abuse?
Certainly, that would be one step that would be helpful.
And I assume you see a lot of demand letter abuse in your line of work based on your description earlier.
Yes, we do.
How many of those do you get in a typical year, or if you feel comfortable sharing that?
Patent troll demand letters. We received 2, and we have we're defending a lawsuit. But I've reached out to other restaurants and retailers, and this is common practice across the industry.
Okay. All right, I see my time has expired. Senator Turpin.